So, good evening, everyone. Thanks for joining our webinar series of Decoding of IBC with Dipti Mehta. Important judgments under IBC of last 1 month, including Disciplinary Committee Orders. So, friends, as usual, we have one panelist, and today we have our very renowned lawyer and my good friend, Mr. Dipti Mehta. And thanks, Madan, for your time, Madan. And let me formally introduce Mr. J.P. Madan is a managing partner, Madan Law Office, advocate and solicitor, registered insolvency professional, vice president, Insolvency Practitioner Bar Association, chairman, NCLT and IBC Committee, PhD Chamber of Commerce and Industry, joint secretary general, NCLT Bar Association, co-chair of Merger Amalgamation Task Force of SOCM, faculty, Indian Institute of Corporate Affairs, Ministry of Corporate Affairs, World Bank, IBBI trainer. I think, Madan, I will just stop here because your profile is such a long that it will take half an hour. So much knowledge, so much experience. Friends, is having so much experience. His expertise include IBC, company law, merger, demerger, acquisition, corporate restructuring, SEBI, capital market, litigation, dispute resolution, commercial arbitration, mediation, conciliation, legal drafting, waiting, real estate, infrastructure, investment, and consumer affairs. And he was, to add something more, he has also been member of following Task Force Society of Insolvency Practitioner of India, member Secretary Standard Board SSB of ICSI, National Council for Corporate Law and CSR of SOCM, National Council for Capital Market SOCM, National Council for Corporate Affairs of SOCM, Corporate Office Committee of PSTI, CCI, Capital Market Committee of PAPCCI, IBC Committee of Bharatiya Vitt Sanskar Samiti, regular faculty at Institute of Direct for its masterclass for director for independent directors. He has written various on this and professional conference, seminar, webinar, workshop, training program, and various professional body, industrial association, chamber, minister, university, institution, regulator on diverse topics on various areas of his expertise. Welcome, Mr. Madan. Thanks a lot for your time, and really we look to see your inputs on the subject. And before we start, I'll request you to say a few words on your topic or the subject, and then we can start.
Thank you, Dipti. I'm really, my apology for not being foremost because I'm sitting at a distant place where even the Wi-Fi is also not working properly. I don't know whether I'm properly audible or not, or properly visible or not.
Yeah, you are audible. Yeah.
Okay, thank you. Yeah, thank you so much. I really appreciate your efforts in updating the professionals, and particularly in the field of this insolvency and bankruptcy code, where day in and day out, the law is being laid. Since beginning, we have seen that there have been 6 amendments to the code. We have seen hundreds of regulations, and how many times, I don't remember, the modifications have been made to the regulations. And on everyday basis, we are receiving the circular, the notification, the clarifications. And where the law is not clear, we are getting the judgment from Honorable Adjudicating Authority, Appellate Authority, and then last but not least from the Apex Court. And sometimes see that we are getting the conflicting judgments from various benches of NCLT, where then it becomes very difficult for insolvency professionals to run the CIRP and the liquidation process. Even I tell you that in today we have won one of the cases in Supreme Court today itself, where the promoter filed a petition against the liquidation on the basis of the settlement, and settlement was not happening, and the stay was granted on the liquidation. Today we contested this case on behalf of the liquidator, got the stay vacated, and the liquidation process will continue. Because there are many stakeholders who do not want RP to work. They treat RP as their enemies. And RPs have to work. RP has to perform the duties under the code, either as IRP or RP or as a liquidator. But the many stakeholders do not want them to work. Then these judgments or these orders, they come to the rescue of the insolvency professional. But however, all this is not we are getting without any bigs and bad. Whenever we do something wrong, IBB as a regulator is there to take us to their fold, issue a show cause notice, and then the orders are passed. And even a minor of the non-compliance is not tolerated. Either we are reprimanded, either we are given an advisory, or in some cases the penalties are levied, and in some cases the registration is suspended, and some cases the registration are cancelled. So it becomes an onerous duty, particularly senior professionals like you, to provide this updation to the insolvency professionals, which actually helps in the insolvency process running their professional duties as IRP, RP, or liquidator. This objective of this and this initiative is really laudable, and I appreciate the same. Thank you.
Thanks a lot, Mr. Madan. We can start the presentation, Disha. Mr. Madan, there is an appreciation, and the participants, they said that I should say only where you are not practicing. And they have said that they are thankful for you to spend your time with them.
Thank you so much. Thanks to you, and thanks for the participant for their compliments. Thank you.
Yeah.
Is my screen visible to all?
Yes,
Yeah,
it's
yeah.
visible, Disha, please.
Yeah. So very good evening to all. So today I am here to present the recent judgments under Insolvency and Bankruptcy Code 2016. So in our very first case, Mr. Vijay Kumar Garg, Liquidator versus Power Grid Corporation of India Limited. This order is given by the NCLT Chennai. In this case, transmission agreement was signed between a company and the corporate debtor, allowing the company to engage the bank guarantee if the corporate debtor progressed on the transmission line constructions. Construction turned adverse. When adverse progress occurred, the company evoked the bank guarantee. Subsequently, liquidator filed a petition with NCLT. The company could not engage the bank guarantee because the corporate debtor was undergoing liquidation. NCLT rejected the liquidator petition. So the issue arose to the NCLT whether a bank guarantee could be evoked during a company liquidation while considering the applicability of a moratorium. So the decision by the NCLT was held that the guarantee falls under the performance of the bank guarantee under the section 331 of the definition in the IB code. Does not fall under the moratorium as defined under section 14 of Insolvency and Bankruptcy Code. So moratorium strictly apply to the assets of the corporate debtor and exclude the bank guarantee, which is neither an asset nor a liability of a company. Consequently, the bank guarantee can indeed be evoked, and appeal was found to lack merit and was dismissed.
Rightly so. Yeah.
So the second judgment over here is the party involved is Dopin Cables Private Limited versus Mr. Praveen Bansal, RP of Abloon Infotech Private Limited. NCLT New Delhi has given the judgment.
Disha.
Yes, sir.
Disha, can you come to the previous slide?
Yes, sir.
Yeah. Previous slide.
Yeah.
Okay. It was not. Anyway, as far as this first case is concerned, which you have just highlighted, this law on the bank guarantee has really been very, very confusing since inception of the code. And
Yes.
again, as I said earlier, we have been getting with the conflicting judgments on the issue of bank guarantee. And every time we have to see what is the latest judgment on this. Now, as per this latest judgment of NCLAT, it says that corporate guarantee This particular guarantee, the performance guarantee, is neither an asset nor a liability of the CD. So therefore, it's not part of the moratorium. Not part of the moratorium, it means if moratorium is not applicable, this guarantee can be invoked. IPs as RP or liquidators should not get emotional or sentimental with such judgment. Whatever is the law as on date, they must comply with that. They must not think whether it belongs to CD or not, or whether it belongs to the outside agency. If the law says that now recent judgment says it's not an asset of the CD, let them treat not an asset of the CD and move forward. If somebody is invoking it, let them invoke it. Let them not be emotional. Let them not contest it and know it's the asset of the CD. Even recent, and let them not challenge the decision. Even suppose adjudicating authority says something, let them not go in for appeal also, because recently, the Supreme Honorable Apex Court has said the RP should not prefer an appeal against the order of NCLT and NCLAT.
Right.
But it does not mean the RP in no case can file. If they are aggrieved party, they can prefer an appeal. If they are not an aggrieved party, they cannot prefer an appeal. In such a case, if adjudicating authority says that this is not an asset of the corporate debtor, RP is not an aggrieved party, RP should never prefer an appeal against such orders of the adjudicating authority, and RP now should consider that this performance guarantee is not an asset of the CD and should move forward.
Right. Rightly mentioned. Yeah, Disha, go ahead.
So the second order is of parties involved are Doping Cables Private Limited versus Mr. Praveen Bansal, RP Abul Infotech Private Limited. So bench here is NCLT New Delhi. Application under Section 7 was filed and ultimately accepted. The appellant, a shareholder of the corporate debtor, made an application requesting the resolution professional to provide document and calculation regarding the admission of financial creditors claim. The adjudicating authority issued an order directing the RP to file an additional affidavit stating that claims admitted along with all the supporting documents. The RP applied to file this additional affidavit in a sealed envelope without e-filing. The request of the RP was accepted by the adjudicating authority. So, Honorable NCLT, wherein the issue that arose consideration was whether adjudicating authority had the authority to direct the resolution professional to provide documents in a sealed envelope without electronic filing. So, decision was Honorable Appellate Body determined that there is statutory requirement prohibiting the sharing of certain information with third party. The overall structure of IBC does not mandate the sharing of all information gathered by the resolution professional with the requesting shareholder. Adjudicating authority, through an application under Section 65, issue a direction to resolution professional to file the documents in a sealed cover without e-filing. Rule 33 of the NCLT Rules 2016 is empowered to call any information or evidence. The resolution plan had already been approved at this stage by the adjudicating authority. The issue raised by the appellant were they considered academic and require no further deliberation in the appeal. Consequently, the appeal was dismissed.
On this also, Disha, please come to the previous slide. I want to read the title of this case. Yeah, it is Dolphin Cables Private Limited versus Praveen Bansal. And the issue involved is, if you read the last line, whether the adjudicating authority had the authority to direct the RP to provide a document in a sealed envelope. Actually, just a minute. Can you hear me? I'm audible now?
Now, yeah, actually after that we lost you. Yeah, you can repeat.
What has happened? Actually, this appeal is against the RP. Actually, sorry, appeal is against NCLT's order and making, because NCLT cannot be made a party, so the RP has been made a party. But the question is whether adjudicating authority has the authority to direct the RP to provide the document sealed envelope or not. So RP has got no role to play. Simply, this is appeal against the NCLT, against NCLT order. NCLT cannot be made a party. RP has been made a party, and appellate authority has decided that yes, adjudicating authority has a right to ask the RP to submit the document in sealed envelope, and the matter stands closed. That's what the crux of this judgment.
Very good observation.
Next, please.
Yeah. So the third judgment is Bittel Teletech Limited versus Erclia IT Service Private Limited. NCLT New Delhi has given the decision. Operational creditors supply a goods to the responder or corporate data. Despite multiple reminders and meetings, payment remained outstanding, leading to the issuance of the demand notice. The notice went unanswered. Operational creditor filed a Section 9 application. Adjudicating authority rejected the application on the ground that the interest mainly accrued during the Section 10A period and no interest can be claimed for the suspension period of IBC, and that the creditor's restriction in the adjusting part payments prevented reaching the rupees 1 crore threshold. Consequently, the appeal was filed with the central legal issue revolving around whether interest during the Section 10A period should be excluded from the threshold calculation and whether the creditor can exercise the discretion in adjusting part payment. The decision is appellate authority held that Section 10A of the IBC prevents the initiation of the CIRP proceeding for the default during its period but does not apply if the default started before the continuation into Section 10A. The default occurred well before 10A, so that adjudicating authority view to disregard the interest accrued during 10A is incorrect. Section 60 of the Indian Contract Act 1872 grants a creditor discretion in allocating the debtor's payment when no specific allocation is indicated. Adjudicating authority finding the operational creditor acted improperly by adjusting payment against the other invoice, principal or accrued interest in unjustified manner. Operational creditor rightfully exercises discretion. The appeal is allowed and the NCLT order is set aside.
Let me clarify this particular case. First of all, let's understand what is the Section 10A period. Section 10A period is period commencing from 25th of March 2020 and ending on 24th of March 2021, period of 12 months. If any default arises during this period, for this default, no application under Section 7, 9 or 10 can be preferred before NCLT. Now, but this order clarifies that if a default has occurred before 25th March 2020, has continued during this period of 1 year of COVID period, and has also continued after the expiry of this period, that is after 24th March 2021. So therefore, this is a continuing default. The period, the 12-month period will not be excluded from this period to count this period of default. This 12-month default shall also be treated as continuous default, and any default arising this period shall also be part of the default amount to calculate the threshold limit of 1 crore. So if the aggregate of default occurred before 25th March 2020, from 25th March 2020 to 24th March 2021, and also default occurring after 24th March 2021, if the aggregate of these three default is 1 year and above, application under Section 7, 9 and 10 can be preferred. That is the crux of this judgment. And as far as the interest portion is concerned, certainly if the interest is to be leviable on the debt amount, that interest shall be levied for this period also.
There are many cases and confusion over this. So this also clarify many things about the
Yes, absolutely.
before, during, after charging interest. Yeah.
Yes, this has actually clarified this entire confusion.
Yeah. Thanks for clarifying.
Yeah.
Yeah, Disha.
Agarwal Polysex Limited versus KK Agro Foods and Storage Limited, NCLT New Delhi. The appeal has been filed challenging an order of the NCLT by which Section 7 application filed by the appellant has been rejected, holding that financial creditor failed to show the nature of transaction between the parties. The issue that arose consideration before the Honorable NCLT were whether to prove a financial debt, a financial creditor has to enter in a written financial contract, whether the appellant from the materials brought on the record was unable to prove the corporate debtor owes a financial debt. So the Honorable NCLT observed that Rule 4.1 of the 2016 rules require Form 1 for initiating CIRP against the corporate debtor, including specific documents. Part 4 of Form 1 deals with particular of financial debt, and Part 5 addresses the particular of financial debt. Documents, records, and evidence of default, where essential evidence for the financial debt is in detail. The Regulation 8, Subclause 2 of the CIRP regulation clears the regulation do not contemplate existence of all documents. Use of word "or" in Regulation 8, Clause 2, Subclause A indicate by any of the document differ to in Subregulation 2, existence or debt can be proved. A financial contract supported by the financial statement as evidence of debt is one of the document in Regulation 8, Subclause 2, but is not an exclusive requirement for proving the existence of debt. The financial contract thus can be very well be furnished to prove the financial debt, where we look into statutory scheme as reflected in the application to Adjudicating Authority Rules 2016 and CIRP Regulations 2016. It is clear that financial debt can be proved other relevant document, and it is not mandatory that written financial contract can only be the basis of proving the financial debt. Thus, it is not necessary that the written financial contract be the only material to prove the financial debt. Honorable Bench concluded that the order of the adjudicating authority rejecting the Section 7 application is unsuitable and deserves to be set aside.
It's a fantastic judgment, has clarified, has removed so many doubts, has cleared the air. Actually, in this judgment, the appellate authority has now very clearly said that to establish a debt as a financial debt, there is no mandatory requirement of having any contract or agreement. Even if a simple plain document or the conduct of the parties, if it can be established that there existed a debt, it had a time value of money, then certainly it is a financial debt, and an application under section can be preferred. There is no statutory or mandatory requirement of having any legal document, any signed document, any signed contract, or any agreement. Through whatever means it can be established that there was a financial debt for which the money was lent and it had a time value of money, application under section can be admitted. This is the crux of this entire judgment, and I really appreciate this judgment.
Yes, actually that makes it clear that no necessity of contract. Every time this used to be the issue.
Yes,
Right.
otherwise adjudicating authority, the other party always say, where is the contract, where is the agreement? And we have seen many judgments against the applicants, where the applications have been rejected under Section 7. But this actually now clarifies the position.
Right. Thanks. Yeah, Disha.
Pan Pacific Engineering Service Private Limited versus Ayappa Hydro Power Limited, NCLT New Delhi, as given judgment. The appellant is the operational creditor and was shortlisted by the corporate debtor by tender process for labor work. The work order was issued in 2013, but the amount was not paid. The default was committed on 15 June 2015. The appellant filed an application before the chairman of MSME in 2019 for the amount of rupees 49,39,296, which was allowed by the order dated 10 November 2020. Section 8 notice was issued by the appellant and the application was filed on 12 November 2021. Adjudicating authority took a view that the default having been committed on 15 June 2015, the application is buried by the time. The appellant challenging the order contended that the default has to be treated as on 10th November 2020 when the order was passed by the MSME Council and the default was committed thereafter. The appellant authority was whether the date of default of Section 9 application was 15/6/2015 or when the MSME Council order was passed. So the decision is the appellant authority, while determining the said matter, held that the date of default in the present case is 15/6/2015 and thus the Section 9 filed by the application is buried by the time. Further, there is no reason as to why again the fresh period of limitation can be given to the appellant from the date of MSME order dated 10th November 2020. Hence, the appeal was dismissed.
Very interesting that you cannot. Yes. Yeah. Sorry. Yeah.
What I'm trying to say, this particular judgment has been passed only on the basis of the facts of the case. And I don't think there is any law point has been established in this case. Because the facts of the case, for the facts of the case, that there was a first default on a particular date in the year 2015. After that, MSME Council came into picture because a matter was referred to them. Then MSME Council passed its orders in that 2020, and then after that, this section 9 application has been filed. What the court has clarified on the basis of facts of the case only that the default occurred in 2015. So therefore, the application under section 9 should have been preferred within the limitation period from the date of default, and date of default is not date of passing of the order by MSME Council.
Yeah, and it is time barred. That's why. Yeah.
Yeah.
Yeah. Isha, go ahead.
Mayura's Industrial Service versus Sram Shriram Shekhar RP, NCLT Chennai has given the order. The appellant and operational creditor has preferred an application under Section 9 of the Code for initiating the CIRP. The commencement of CIRP, the COC has passed a resolution for the withdrawal of CIRP, and the RP in furtherance of the same had preferred an application before the adjudicating authority under Section 12A for the withdrawal. The said application was allowed. That it becomes pertinent to mention the RP along with Section 12A application had not filed Form FA. The OCS preferred the appeal before the Honorable NCLT. The issue which arose before the Honorable NCLT was whether the adjudicating authority was correct in allowing the withdrawal of CIRP without hearing the appellant. The decision is appellate authority held that the jurisdiction of adjudicating authority, Section 12A of the Code, is very limited. The COC has approved the withdrawal of the CIRP of the corporate debtor with more than 90% of the voting share. It is open to an adjudicating authority to reject the application. Further, the appellate authority rely upon the judgment of Honorable Supreme Court passed in the matter of Rajakumar versus Naranjan and others, wherein it was held that a company director is entitled to seek withdrawal of an application initiating CIRP if is able to establish that he would be settling the dues of the creditors. The corporate debtor has already settled the dues of two operational creditors, SS Metal and Amanza Agency and Services, to their satisfaction and made a draft already in favor of Mayura's Industrial Service. Thus, the appeal was dismissed.
You know, the law with respect to Dipti, you want to say something? Yes, please.
No. You go ahead.
The law with respect to withdrawal of application. Earlier, there was no clarity before 2018. After 2018, a clarity has been provided. Section 12A has been added to the code, and then we have seen the respective regulation also. A conjoint reading of the Section 12A and the regulation, it lays down the law that when and how this application for withdrawal can be filed under Section 12A before constitution of COC and after constitution of COC. Different set of process has been established for that as prescribed in the code as well as in the regulations. But now the question arises whether if Form FA is not there, will it be treated as withdrawal? Or who can prefer an application? If you see, as per law, application is to be preferred by the RP. But for this purpose, for withdrawal of the application, my personal experience is you have to go through various pronouncements. And in the pronouncement, the judicial pronouncement, you will get the latest law. And this is one of such cases. It is immaterial that who prefers an application for withdrawal. It is immaterial whether the application is proper or not. It is immaterial whether Form FA is there or not. If there is a settlement between the two parties, if a withdrawal application, whether in Form FA or not, has been signed, it has been preferred before adjudicating authority, and there is a backing of COC in case COC has been constituted. So if COC has been constituted, COC has passed a resolution with 90% of vote. In such a scenario, adjudicating authority will allow this withdrawal, because again, we have to go through the preamble of the code, which actually talks about rehabilitation, revival, resolution. And for that purpose, if settlement has been there, adjudicating authority will not come in the way by simply saying that you have to follow the law, you have to follow the regulation, and the application has to be in this format and all that. So there, and collector said the amount has been settled between both the parties, application is there, it is immaterial, 90% voting percentage is there, it is immaterial who has preferred the application and whether the application has per format or not. And there cannot be any better example in the country except but our own Madam Dipti Mehta, where Section 12A has been used during liquidation also.
Yeah,
Law does
liquidation
not
going concern.
law does not talk about settlement during liquidation, but in her case, the settlement has been allowed even in case of liquidation also.
Yeah.
What else can we say?
Yeah, so in my first case only, that liquidation as a going concern, it was also we made the liquidation as a going concern before the regulation is passed by the IBBI. So even COC decided that time. And then liquidation as a going concern before, after Corona, that because of the delay, then it was decided to settle. And again, to my proud, I'll say, it was again the first case where 100% payment done to creditors. All employees paid, settlement to all operational creditor, even though they have not filed a claim. And the company is running. So they have seen that what is wrong in that, there is no opposition. And it's such a wonderful settlement where everything is, everyone got everything. So why should not we do this? And they allowed it. So if your intent is good, court has taken positive and they are taking that way. That the purpose of the law is to survive the company and the business. Thank you. Yeah.
So here our own Madam Dipti Mehta has laid down the law and has opened the window of hope for many ailing corporate debtors and its employees. Hats off to you, Madam Dipti.
Thank you. Thank you. No, thanks. Yeah, Tisha.
Department of State Tax versus RP of Calcum Industries, India. NCLT Mumbai bench has given the order. Public announcement was made on 1st October 2019 and the due date for filing the claim was 29 December 2019. The Department of State Tax filed her claim on 8 October 2021 after the delay of 650 days. The COC has already approved the resolution plan on 13 October 2020. And RP has filed IA for the approval of resolution plan by adjudicating authority, and the same is pending before this tribunal since 18 November 2020. The RP, via its email dated 13 October 2021, rejected the claim of appellant, stating that the COC has already approved the resolution plan on 13 October 2020, and the same is before the adjudicating authority for the approval. Two applications are filed by the applicant under Section 60, Subclause 5 of the IBC, seeking direction to the resolution professional to accept the claims of the applicant and dealing in the same with the provisions of the code. Decision as adjudicating authority held that we cannot lose the sight of the object of the code, which inter alia aims for the insolvency resolution of the corporate debtor in a time-bound manner. Code has also altered the order of priority of payment of government dues when compared to the earlier Companies Act. For all the reason, there is no merit in the present application except to the extent of that if the VAT GST liability as contended by the applicant was rupees 2,89,980 under MVAT and rupees 7,12,870 under GST. For the relevant year 2012-13, aggregating to rupees 10,02,850, was reflected in the books of corporate debtor and the date of preparation of the memorandum information, then the RP should have considered the same in the information memorandum. RP is directed to consider such government dues if appearing in the books of account of the corporate data.
This is such a case, again, one of the most gray areas,
Yeah.
where in many of the cases we see on RPs on everyday basis, they are running here and there in the court. And this is with respect to admitting the claim which has been filed belated. As per, if we go by the law says the claim is to be filed within 14 days from the date of commencement of CIRP. Then it further says up to 90 days a claim can be filed along with proof of claim. After 90 days, no discretion with RP. It was earlier. Later on, the principal bench of NCLT decided that even if the claim is being filed belated, but before the plan is being approved by COC, the RP must not, no application is required, RP must not come to the court, and the claim must be admitted by the RP. But later on, last year, we had a judgment from NCLT in a case of KST versus RPS Infra. There, the law was laid down by NCLT that after 90 days, RP has got no authority at all to admit a claim. So RP stopped accepting the claim after 90 days. In one of the cases, I advised my RP to take a pro bono matter to help these home buyers. Number of claims were received after 90 days. I asked the RP, you go to NCLT at final application on behalf of all of them for seeking condonation. NCLT says, who are you? What is your locus? Why have you come to us? We cannot admit any application on your behalf. Let every applicant come to us and file an application for condonation of delay. So RP withdrew the application. And after that, in that case, I tell you, around 130 applications were filed later on. But in all the applications, the delay was condoned with a cost of 10,000 rupees to be paid to the RP.
Oh.
Yes. And that amount shall be used by the RP in the CIRP cost. No, it's not going to the personal pocket of RP. It will remain with RP to be used in the CIRP cost. But now what happened? Last month, we have seen a judgment.
Yeah, amendment.
First of all, from Honorable Supreme Court. Honorable Supreme Court, because the matter went to Supreme Court, that Mukul Kumar versus KST Infra. In that particular case, Supreme Court has laid down the law now, but that was a commercial creditor. We need to distinguish between a commercial creditor and a home buyer and government dues. In case of a commercial creditor, Supreme Court has said that once the announcement is there in the newspaper, it's a public notice, you should know that, and after 90 days, your claim cannot be admitted. However, in that particular case, the claim was filed after the plan was approved by COC. An application was filed pending before adjudicating authority. Supreme Court very categorically said at this stage, no claim can be entertained and the appeal was dismissed. Now, to provide further clarity, on 18th of September, Honorable our IBBI has come out with revised regulations, and as per those revised regulations, RP can admit a claim till the date of the latest issue of RFRP document. It means if there are 3 RFRP documents, the last date of the date of issue of the 3rd RFRP document shall be treated as the last date of accepting the claim. And even after that, if the claim is being received by RP till the date of approval of the COC of the resolution plan, for that, during that purpose, if a claim is received, now the RP will file an application on behalf of all those claimants before the adjudicating authority, the step which I took in the January of this year. Now RP shall file a consolidated application on behalf of all those applicants, all those claimants who are filing the claim late after issue of RFRP document, seeking condonation of delay in filing the claims. And that's the latest law. And this law also says, if a plan has been approved by COC, it is pending before adjudicating authority. At this stage, no new claim can be entertained. This actually clarifies the law, and I'm in favor of this judgment. It will really help the many RPs.
Yes, because once COC has approved, that means every adjustment or every creditors have been approved and taken care. Now, if they allow this any claim, that means again every creditor has to check, and that bringing everyone to the agreement is the most challenging task. These are really,
Yes.
this really clarified everything recent amendment.
Yes.
Yeah. Yeah, you can go ahead, Disha.
Kunal Private Limited versus CA Sai Ramesh, NCLT Hyderabad branch has given this order. Operational creditors of the corporate data, Gayatri Project Limited, which was admitted into CIRP on 15 November 2022. Initiation of CIRP process on 13 December 22. The applicant has approached the resolution professional by making a claim of 4 crore 56 lakh 14,669 rupees, comprising of principal outstanding amount of 3 crore 46 lakh 48,872, along with to up-to-date interest of 1 crore 9 lakh 65,797. RP by its email dated 10 January 2020 admitted the claim of the principal amount of rupees 3 crores 46 lakh 48,872. The interest component of the claim rupees 1 crore 9 lakh 65,797. RP sought the detailed working from the appellant, which was submitted to along with the relevant invoices. The applicant was then informed on 18 March 2023 by the RP that only the principal amount was admitted and the interest claim was not. Decision in this case: a default occur on the part of the corporate debtor. Absence of pre-established convention for charging interest in the cases of delayed payment become irrelevant when the payment against the invoices were not received at all, and the acknowledged default of the principal amount happened. The applicant invoked the clause specifying an 18% interest charge that was clearly stated on their invoices, which accompanied the supply of goods to the CD before the initiation of the CIRP. The appellant is undoubtedly the claim within the meaning of Section 3.6 and a debt on within the definition of terms under Section 311 of IBC. The respondent RP is therefore directed to admit the interest amount of rupees 1 crore 9 lakh 65,797 beside the already admitted claim of rupees 3 crore 46 lakh 16,902 towards the claim of the application as operational creditors. The application is allowed.
Yeah. So again, here that interest, if there is in invoice it is provided and it is not objected, then it should be allowed. So, Madan, any comment on your part, or we can go ahead?
Yeah. You know, it has been laid down in many judicial precedent that RP is not an adjudicating authority, and he must not try to be an adjudicating authority also. However, simultaneously, if an application has been admitted under Section 7 or 9 of the applicant on the basis of a particular default amount, it does not mean that the adjudicating authority had adjudicated the default amount. RP has got all the rights later on to while reconciling the claim on the basis of the records of the CD as well as the records submitted by the applicant, at that time claimant, along with the claim form. He can always revise this claim. But as far as this case is concerned, because the interest is there, part of the invoices, so RP cannot disallow the interest simply because he cannot say, no, you are operational creditor, interest will not be paid. If it is part of the invoices, interest has to be paid.
Thanks. Yeah, Disha, go ahead. Disha?
Disha,
Yes.
you may go ahead.
Yes, sir. Kanwal Goyal Liquidator versus Uttar Haryana Bijli Vitran Nigam Limited, NCLT Chandigarh bench has given the order. The respondent and admitted that there was a refundable deposit of rupees 59,40,480, out of which rupees 34,05,003 has been refunded, and the amount of rupees 9,69,977 has been adjusted against the existing liability. Therefore, an admitted fact that an amount of rupees 15,65,480 is still outstanding to be paid to the corporate debtor. No justification for asking the corporate debtor to make use of the grievances cell of the respondent to get the undisputed refund of rupees 15,65,480. Under the provisions of the IBC, this refund is a part of the liquidation estate of the corporate debtor as defined in Section 36 of the IBC Code. And the liquidator has a right to recover the same and hold it as a fiduciary for the benefit of all the creditors. The respondent are directed to refund the amount of rupees 15,65,480 to the appellant within 15 days of this order.
I don't think this particular judgment requires any explanation or clarification. The facts are very clear. Approximately 60 lakhs is the outstanding amount to be paid by this Bijli Vitran Nigam Limited to the corporate debtor, out of which around 35 lakhs has been paid. Around 10 lakhs has been adjusted against the existing liability. Remaining liability of the Bijli Vitran Limited towards the CD is 15 lakhs of rupees, and that was a refundable security. So it has been held by the Honorable Adjudicating Authority. This 15 lakh is part of the liquidation estate of the corporate debtor, and this Bijli Vitran Nigam Limited has to refund this amount of 15 lakhs to the liquidator.
Yeah. Thanks. Go ahead, Disha.
Ahluwalia Contracts India Limited versus Jasmine Buildmart Private Limited, NCLAT New Delhi, has given the order. The appellant and operational creditor initially engaged in an agreement with the corporate debtor, leading to an unpaid bill. Subsequently, a Section 8 application was filed, followed by Section 9 application. Section 9 application process, a term sheet of settlement, including securities, was executed, wherein the corporate debtor acknowledged the unpaid amount but later failed to fulfill the agreement. Another Section 9 application was submitted but was ultimately rejected by the adjudicating authority, contending that the debt did not arise from the supply of goods or services but rather from the breach of settlement agreement, make it ineligible as an operational debt. The issue which was aroused within the appellate authority was focusing on whether a settlement agreement qualifies as operational debt and whether the filing of a claim in a security undergoing CIRP can hinder the claim of operational debt or not. Decision: appellate authority determined that the operational debt in a question was related to the payment of bill submitted by the operational creditors, and a settlement agreement had been established for this purpose. The payment was not made as per the settlement agreement. The corporate debtor liability to make a payment and the operational creditor was justified in filing the Section 9 application. It was clarified that security CIRP does not affect the Section 9. While the amount received by the appellant during CIRP may be adjusted, this cannot be the reason to hold the Section 9 application. Therefore, the adjudicating authority decision was errored and set aside.
Now, this judgment of appellate authority is actually disturbing for me, if you ask me. You know, earlier what was happening, a Section 9 application is admitted, both the parties settle, and application is withdrawn. Rather, I'll tell you that application is pending before admission. Application is filed before admission, both the parties are settling and applications are withdrawn, subject to the liberty being given to the applicant if the settlement terms are not adhered to by the corporate debtor. The applicant will have liberty to file another application for revival of his original Section 9 application. Later on, the adjudicating authority stopped passing such orders whenever a settlement was happening before admission and an application is filed for withdrawal of the original application. Adjudicating authority used to say, okay, we are allowing withdrawal, but with no liberty to revive the original application if the default happens in future. But now this particular judgment says if there is a settlement before admission, settlement is not adhered to by the CD. Again, there is a right with the applicant to revive his original Section 9 application. The situation which used to be there in the year 2017, 2018, 2019, that situation has been revived now through this judgment. Even though a settlement fails, the applicant has a right to revive his application, original application under Section 9. Dipti, your comments on this?
So what you are telling that it should not be allowed to be revived?
I'm saying this was the legal position. Earlier it was being revived. Later on, adjudicator used to say, no, you cannot revive it. But now adjudicating authority is saying again, you can revive it. I'm simply saying the situation is that the legal position is getting changed. I'm not favoring or opposing it. I'm saying there is no stability on the legal position.
Just that it is, but per se, I agree that it should be allowed.
I'm in favor of revival. If you ask me, I'm in favor of revival.
Yeah.
But law should remain the same.
Yeah, that is. There should be clarification or that kind of thing. Like in earlier cases that they clarified by. Should be settled. I fully agree. Why unless the same thing you file again you delay that? Why it should be done?
Otherwise, there's no liberty being given to the applicant. Actually, this provision or this legal position was being misused by the corporate debtors by entering into settlement.
Yeah,
and now it clarified the position.
And then not following.
Yes.
Yeah. Yeah, go ahead.
Yeah.
Suneco Marketing Private Limited versus Girish Sriram and others. NCLT New Delhi has given the order. RP has received resolution plan from 2 PRA, Independent Sugar Corporation Limited and AGI Greenpack Limited. Independent Sugar Corporation Limited sought clarification from the RP with regard to approval of CCI. CCI is Competition Commission of India, as well as the timelines for obtaining such approval as the RFRP has contradictory clauses. Clarification that in light of the available jurisdiction, the RFRP granted relaxation to the resolution applicant to procure the CCI approval post the approval of the resolution plan by the COC. Independent Sugar Corporation Limited received the requisite approval from the CCI prior to the approval of resolution plan by the COC. However, the application filed by the AGI Greenpack Limited was declared as not valid by the CCI. Later, resolution plan submitted by AGI Greenpack was approved by COC. Application for the approval of resolution plan was preferred before the adjudicating authority. In meantime, Independent Sugar Corporation Limited also preferred an application before the AA, seeking setting aside the selection of their resolution plan submitted by the AGI Greenpack Limited. CCI granted the approval to the AGI Greenpack Limited subsequent to the approval resolution plan by the COC. Thereafter, the adjudicating authority rejected the application filed by the Independent Sugar Corporation Limited. The issue which was raised before the Honorable NCLT was whether, as per Section 31 of the Code, the requirement of approval of the CCI prior to the approval by the COC is mandatory. The decision is appellant authority held that RPI subsequently clarified that approval can be obtained even after the approval by the COC, which was in accordance with the relevant legal position as settled by the NCLT in SL Mittal India Private Limited versus Abhijit, wherein Honorable NCLT had held that the provisions to the subsection 4 of Section 31 of the IBC Code, which relates to obtaining the approval from the CCI under the Competition Act 2002, prior to the approval of such resolution plan by the COC. NCLT held that it is open to the COC, which looks into viability, feasibility, and commercial aspects of the resolution plan, to approve the resolution plan subject to the approval of commission, which may be obtained prior to the approval of the plan by the adjudicating authority under Section 31 of the Code. The appellate authority held that Section 31, subsection 4 proviso has to be read to mean that the approval by the CCI is mandatory. The approval of CCI prior to the approval of COC is directed. Thus, the appeal was dismissed.
Let me clarify the facts. There are two resolution applicants. In this case, the successful resolution applicant requires the approval of Competition Commission of India. There are two resolution applicants, A and B. Both of them approach CCI. A gets the permission from CCI and B's permission is rejected. Now, after this, all this happens before COC considers the resolution plan. A receives approval of CCI, B's approval is rejected. But now after that, when COC considers the resolution plan, COC approves the plan of B, which did not have CCI approval earlier. Now B again approaches CCI, and now at this stage B gets the approval from CCI. Now B's plan is approved by COC, and now at this stage B gets the approval of CCI also. Now A, being an aggrieved party, approaches NCLT. NCLT passed an order. Let's not go into the merits of this, whether CCI approval is prior or later on. The only issue is that CCI approval is mandatory. Prior or later on is directory. So what is mandatory? CCI approval, whether it is obtained prior or whether it is obtained later on, that is directory. In this case, B's got CCI approval after the approval of the plan by COC. B's plan was approved by COC. Therefore, the COC's decision to approve the plan of COC and of granting this unit, this company to B is absolutely valid, and his application is dismissed.
What have you done on this? Yes, how you look at this judgment?
Dipti, sorry, you're not audible.
Divakar Sharma.
What is your view on this judgment? Because they are that look at the serious and that see decision is go and go for the compliance of the lawyer's plan. Straight to the lawyer's action. So we should go with that, right? What is your observation?
Yeah, Disha, carry on, Disha.
Yeah. Divakar Sharma versus Anand RP, NCLT New Delhi has given the order. IA filed by the appellant who claimed to be an ex-director of the corporate data who has resigned in February 2014. CRP against the corporate data Shubha Kamna Buildtech Private Limited commenced on 26 November 2018. Resolution plan was approved by the adjudicating authority on 12/9/2022. The appellate submit the appellant was also a shareholder of the corporate data. Whether the shareholding of Shubhakama Builder Private Limited in two companies, namely Rudra Buildwell Projects Private Limited and JSS Buildcon Private Limited, has been taken into consideration while assessing the assets and the liability of the corporate data. NCLT held that the information memorandum must have been prepared in the CRP and the Form G was issued for the resolution plan, including the details of the asset. At this stage, no relief can be granted on the prior as made in the application.
No, this is again.
Supply a copy of resolution plan approved by the adjudicating authority. NCLT held that.
Disha, let me summarize this case.
Okay.
You know, all COC members have a right to receive copy of the resolution plan and copy of each and every document placed before the COC or which is a subject matter of any of the agendas of COC. This is with respect to COC members. But there is always a confusion that the participants at the COC who are not members of COC do they have right to receive all the documents, information, or resolution plans? For this purpose, there is some clarity in the regulations, but still there are many judicial precedents in the light of which we have to read the regulations. There has been one judicial pronouncement where it has been said categorically that the directors of the CD have a right to receive the copy of the resolution plan. Now, if you read the regulations say the participant have a right to receive copies of the documents which are placed before the COC and which are necessary for the purposes of agenda item of the COC. Now, what is that document that has not been clarified? And even as far as this order is concerned, I will have to go through into detail of this particular judgment to come to a conclusion. But what has happened in couple of days before, 3 days before, actually before NCLAT, that a participant is not having a right to receive copy of information memorandum, because as per NCLAT, information memorandum is not a document which needs to be circulated amongst all the participants. So, on the basis of facts of each and every case, this is to be discussed and decided whether a participant who is not a member is having a right to receive all the documents or information as tabled before the COC. According to me, there is no clarity even till date. So if you get a copy, it's fine. But if you don't receive a copy being a participant, you may always prefer an application and let the application be decided on the basis of the facts of each case. Dipti, your comments, please.
Documents are even COC also members are different kind of document, because if you check that COC also can ask certain documents which are part of the agenda or which are relevant to the accounts and all that. But many documents which are not relevant to that, I want to verify that it is within the regulation given, or and especially or something asked for. Different interpretation. You rightly say that if there is a doubt, there is no issue, we can take direction and then only share the document. Yeah, Disha, please.
So now the disciplinary committee orders. So case 1, the contravention was charging the excess fees. It is noted that the white email dated 22nd March 2020, the board has pointed out incorrect percentage applied by the liquidator for calculation of his fees as liquidator.
So Madan and participants are also traveling, so my net connectivity getting affected. So if I'm disconnected, please forgive me. You can go ahead, please.
Okay, I'll do that.
It is noted that the white email dated 22nd March 2021, the board has pointed out the incorrect percentage applied by the liquidator for calculation of his fees as liquidator, and have brought to his notice excess fee drawn charge in the liquidation process of the CD 1, 2, and 3. It is noted that in his reply to an DIR, liquidator had admitted of having charged excess fee as liquidator as per the regulation 4 subclause 3 of the liquidation regulation by calculating first 6 months from the date of the receipt of the first tranche of a sale proceed of the asset instead of from the liquidation commencement date, and only after being pointed out by the board he refunded the excess amount to the liquidation account of the respective CD. The submission was made by the IP. Liquidator submitted that he had not violated the provision of Regulation 4 subclause 3 and the fee was calculated by him strictly in accordance with the provision of the state regulation. However, due to no clarity with regard to start of the first 6 months, the error has taken place, which was purely an account of wrong interpretation and understanding of the provisions. Order, the DC in exercise of the power conferred hereby imposes penalty of rupees 1 lakh on the liquidator and further warns liquidator to be more careful and strictly comply with the provisions of the code and regulations made thereunder.
Disha, this is an order of the Disciplinary Committee of our own regulator, Insolvency and Bankruptcy Board of India. I'll refrain from commenting on this order, but I will say that as far as this order is concerned with respect to, because it's seen, because all the facts are not there, like, like all the facts are there in the court orders or judgments. All the facts are not there in such orders of the Disciplinary Committee. But as far as the language of the regulation with respect to distribution of fees concerned, certainly there seems to be some sort of ambiguity. That is why recently IBB has also come out with a discussion paper on how this fee of the liquidator is to be calculated. Number one, on the basis of the amount collected or amount realized, and number two, amount being distributed, and then the period. So on all these three issues, IBBI is coming out with more clarity. That is why IBBI issues a discussion paper. Discussion paper is open for our comments. So whatever the underlining issue in this case is, we have now the discussion paper before us, and we can give our comments so that tomorrow we will have a better clarity on this amount to be distributed, amount to be the realized, and the period for which the liquidator is entitled to his fee.
Madan, I think the IBBI is come out with the clarification, and they have directed to calculate, and if you have received more than that, because in past, then you have to return back the money. That way they have directed. So it is in effect of coming retrospectively. That how, from which date you have to calculate, they have told. And if you have calculated wrongly, because there was no interpretation and you are on more, then return back, so that they will not be penalized as that way it is come. So
Okay.
many are discussing on the subject. Yeah. Yeah.
Okay.
And
Thank you.
yeah, Disha.
So case 2, contravention 1, non-acceptance of claim. Financial.
1 minute, Disha. 1
Yes.
minute. There are few raise of hands is there. There are 2-3 only disciplinary cases, and then we will allow if anyone want to speak. Yeah, Disha, go ahead.
It is a financial creditor who had filed.
On this, just a minute. On this, Dipti, I would like today, as the time is over, number one. Number two, the disciplinary issues are, as far as disciplinary issues are concerned, Dipti, may I request to have another webinar on the disciplinary issues only? Because if we start discussion on disciplinary cases today, certainly we will be in trouble. We have already overshot the time by 10 minutes. It may take another 5-10 minutes.
No, what we will do, we'll just, So what we will do, just we will, or what you think we should conclude, just we'll give the information, we will not comment as such. Right. So that at least recent judgment, all IPs know that what is taken care. Right?
No, but we can have a thorough discussion on this judgment, but we need to have a separate webinar for that.
Okay. You suggest that way, then we will do that way. No issue.
Yes. And let's devote at least 2 hours on that. Not 1 hour.
Okay.
Yes. Yeah.
Okay, fine. Then let me allow the.
And my apologies to all those IPs who are raising the hand to discuss this issue. I think that they will have a better opportunity next time.
No, let's see that they want to speak on that or any other thing. Mr. Lalit.
Okay, that's okay.
Mr. Lalit, Mr. Sonu, and Mr. Rajesh. And Mr. Ravi.
Ma'am, can I stop sharing this screen then?
Yeah.
Yes, Disha, you must stop sharing.
Disha, thanks a lot. You can unmute yourself, Mr. Ravi, Mr. Rajesh, Mr. Sonu, and Mr. Lalit. Or by mistake, they have done. I don't know.
Thank you so much. This was very informative. We are very glad to attend it. And as rightfully said, we can take our next session on disciplinary, especially that's very, very important.
Okay,
we
if
should-
public demand is there, we will do that, and Madan, you will be there, huh? You have to be there.
Yes, definitely, certainly. Thank you so much. Thank you,
you.
sir. Dipti Madan, sir. Thank you. That was very nicely explained by you.
Dipti Mehta
Yeah,
sir,
thank-
good evening sir. Lalit Maitri here.
ललित जी नमस्कार.
सर बहुत अच्छा लगा सर. I generally attend आपका सेशन में अटेंड करता हूँ.
Thank you.
Sir, thank you very much.
Thank you so much.
Sir, thank you very much.
Yeah, Mr. Rajesh, you also raised the hand.
Yeah, Madan sir, I am Ashok Jha. Just I want to ask a little question. Sir, what is happening? Gujarat Sales Tax Department has given us the order which is post CIRP, and they have said that as per Rainbow order of Supreme Court, you put it under secured creditor, because at the time of your claim date, we don't have order, so we could not raise the claim. But I have heard that Supreme Court has dismissed that Rainbow order by certain bench. So what should we do, sir?
Supreme Court had not dismissed. However, in case of Raman Ispat, to
Yes, sir.
some extent, Rainbow has been overturned. To some extent, I'm saying. But after that, we have seen number of unclear judgments also, which actually is clarifying this position. If you talk about Rainbow, Rainbow has also not clarified the position.
Right, sir.
And if you please go through the review order of Vidarbha Industries. In
Okay, sir.
Vidarbha Industry review order, Supreme Court has said that if we pass a judgment, that judgment is on the basis of facts and circumstances of that particular case, and it does not become a statute.
You're right, sir.
You please apply Vidarbha review in Rainbow and consider this. Whatever has been decided is Rainbow. That is not a statute. That is applicable only in Rainbow on the basis of facts and circumstances of Rainbow only. For every
Right,
other
sir.
case, please apply your own wisdom. Take a call. Let the other party go to NCLT and file an application. And at that point of time, you place your issue. Let the other party place their issue, and you contest it.
Right, sir. Right, sir. Rainbow will not apply to all cases. Right, sir. But sir,
Yes,
Raman,
Rainbow will. This is my personal feeling. Rainbow will not apply to all the cases.
yeah. But sir, Raman Ispat, what is happening?
And also in case of Rainbow, actually Rainbow it was CIRP. Raman
Right, sir.
Ispat it was liquidation. So
Yes.
we cannot say that Rainbow has been reversed. We cannot
Yeah,
say
yeah.
that also.
This is what I was just asking. Raman
Yes,
Ispat
yes,
is for this liquidation.
Yes,
So,
yes.
so we should not put under secured creditor to their VAT order.
आप तो वो
जी, जी।
करिए जो आपके
जी,
सामने
sir.
डॉक्यूमेंट्स है. On the basis of that you take a call whether they are first of all they are financial or operational, and then whether they are secured or unsecured on the basis of the available information, and again then decide whether you are undergoing CIRP or you are undergoing liquidation.
We are going under CRP, sir.
Whether 53 is applicable to your case or not in CIRP. So
Yes, sir.
decide
53.
on the basis of the facts of each case.
We actually, sir, we have not considered their this claim
नहीं,
because their claim
one
is
to
filed
one
after the.
जहाँ सा
जी, sir.
1-to-1 बाद में डिस्कस करेंगे.
Right, sir. Right.
Right.
Yeah, thanks. Mr. Rajesh, I think you also raised hand. You want to ask something?
राजे तो पंकज जी भी कुछ कहना चाहते हैं. I think.
Yeah, may I? I just wanted
Yes,
to
please.
compliment Dipti Madam. Back to back seminar. Tremendous capacity.
Yeah, thanks a lot.
Okay.
Tremendous capacity and capacity building of the professionals.
Yes, ma'am.
Thank
Yes,
you.
sir. True.
In this profession, we have to really learn from each other, and that helps
Absolutely.
each and everyone, honestly. Yeah, anyone wants to speak, or we will close this session? If anyone, otherwise I will close the session.
I think
Because
राजेश जी का
actually-
hand raised है, लेकिन राजेश जी unmute नहीं कर रहे हैं.
I know, पता नहीं, by mistake में भी हो गया होगा.
Yeah.
Yeah, not an issue. I think we should also relieve Mr. Madan. He is actually on holiday, but still I really grateful to Mr. Madan for giving the time. And he has attended from the place where the web, the net connectivity is also weak. Thanks a lot. But Mr. Madan, as you promised, now we will have for disciplinary order and you have to be panelist now. You have only promised to all our participants.
Anytime. And I'm always there for you, Dipti, and for IPs. Thank you.
Yeah, thanks. One of the participants
No.
says that I am watching from London. Thank you, Mr.
Oh,
Kishore.
wow. Thank you so much.
आपके चाहने वाले बहुत हैं, Mr. Madan. So everyone wants you to be back again. Okay?
I'm honored. Thank you.
Thanks everyone for your participation. Thanks a lot.
Thank you. Bye.
Please support it.
Thank you, everybody. Have a great time. Thank you. Bye-bye.
Thank you. Bye.